the most talked about changes made to the Workers' Rights Act through the enactment of the Finance Act 2023 is the introduction of what we call the 4-day work week. Very simply, what it means is that a worker who works X number of hours over 5 days in a week would be working the same number of hours but over 4 days instead of 5 days in that week. And different jurisdictions have already implemented this incentive to certain workers or employers, and they've got different models. But the model that has been adopted by the Mauritian jurisdiction, by the legislator here, is as follows. So there's two scenarios. Either the employer is requiring the worker to work 4 days instead of 5 days, but I said the word requiring, but the employer still needs the consent of the worker and needs to give 48 hours notice to that worker. The second scenario is where the worker makes a request to the employer and asks to work for 4 days in a week instead of 5 days, and the employer's grant of that request would be subject to their operational requirements. We've had the opportunity to work with very talented HR professionals and management teams over the past years, and we know that this is a topic that is already on their radar. There's a lot of research that has been done internationally on whether this works in terms of improving efficiency, productivity, work-life balance. The research papers show the pros and cons of the concept of a 4-day work week. But other than operational requirements, there are certain legal considerations if a business wants to implement the 4-day work week, or if workers request to work on 4 days instead of 5. And some of those legal requirements need further consideration and perhaps need to be factored into policy at work, which would explain, for example, how in that situation the employer would compute leave entitlements, given that a person who's working 4 days is actually doing 5 days worth of work in the 4 days, so basically working 1.25 days in one day. So that affects computation of leave entitlements. When it comes to remuneration, what is provided in the Workers' Rights Act following the amendment through the Finance Act 2023 is that the worker who would be working on the 4-day week would be entitled to the same remuneration as they would if they were working 5 days, and that's because they're working the same number of hours that they would have been working over 5 days, but this time over 4 days. This is different from other models that have been implemented in other countries, very often on a pilot basis. For example, we have the model that's commonly referred to as the 100-80-100, which means 100% of your remuneration for 80% of the current time that you're working, but subject to 100% productivity. If the productivity levels over the 4 days is the same as over the 5 days, although the worker is working shorter hours, they are entitled to 100% of their salary. So that's not what the Mauritian legislator has catered for in the Finance Act, which has amended the Workers' Rights Act. But nothing prevents an employer from considering whether this is also a model that they would like to consider and implement in their organization.
The legislative changes in the area of employment law signify that management officials shall have to review their internal leave policies to reflect the amendments accordingly. For example, the introduction of workers' entitlement to leave to look after their parents and grandparents, the removal of the 10 days cap concerning workers' entitlement to leave to care for sick child, and the prolonged leave for female workers who suffer a miscarriage. The aim of the provision for employers to be entitled to a maximum monthly allowance of 15,000 rupees for 24 consecutive months for the recruitment of a female person or a person with disabilities, along with certain other specifications, is to encourage the employment of people with disabilities. However, there is already existing legislation requiring employers having a workforce of at least 35 workers to employ a number of disabled persons, which is equivalent to 3% of the workforce. While the actual application and monitoring of the existing provisions are questionable, it is also debatable whether employers would be realistically incentivized to employ people with disabilities following such an allowance, given that there may be implications like, in certain cases, adjusting the infrastructure at the workplace and also upskilling of workers.
We know that availability of manpower is a topical issue for many businesses. Presumably with that in mind, the law has been amended to bring two major changes. Firstly, applications for work permits now will have to be made to the Minister through the National e-licensing system. Such e-applications will have to be made in compliance with the guidelines issued by the Ministry. Secondly, an application normally has to be determined within 30 working days of the submission of a complete application, unless the applicant has received, during that period of 30 working days, a notification from the Ministry that the application is still under consideration. Question is, what happens if the application has not been determined within the 30 working days, nor has the applicant been notified that the application was still under consideration? The law, and this is the second change, now provides that in such a situation, it will be deemed that the application for the work permit has been approved. It is expected that these changes will be advantageous to the business community in its search for manpower.
Let's talk about childcare facilities. There are two interesting measures that have been introduced through the Finance Act 2023. The first one to consider is the requirement for certain employers to provide free childcare facilities for their employees. That concerns employees who have more than 250 workers in their organization. By the term workers, what we mean is employees who earn up to 600,000 rupees in annual basic salary. So if they have more than 250 workers, they need to provide free childcare either on the premises of the business, of the workplace, or within 1 kilometer from the workplace. And this applies to kids under the age of 3 years. The second interesting measure that has been introduced as well is tax deducted. It's enhanced tax deduction for capital expenditure on the setting up of a daycare center. That tax deduction of capital expenditure was already available for the setting up of creche for the purposes of the employees' young kids, and that has now been extended to the setting up of daycare centers as well. If the employer is setting up or acquiring or making any sort of capital expenditure to provide daycare facilities to their employees, that would be tax deductible, and it would be an enhanced tax deduction of 200%. What's interesting is that this enhanced tax deduction is not only applicable or available to the employers who are required to provide the free childcare facilities, those we talked about under the first point, meaning the employers who have more than 250 workers. So even the employers who are not required to provide the childcare facilities, if they do, they are entitled to the tax deduction on the setting up of those facilities. Whether they choose to is another matter, but if they do, there's different legal considerations in how to structure the operations and the running of the daycare facilities. Most employers, unless they are in the business of providing daycare to children, would probably not have any idea how regulated this space is, and would probably have an idea of the liabilities that they may expose themselves to and that they need to mitigate and manage. There's different structures that are available and possible to accommodate the setting up of childcare facilities and providing free childcare or paid childcare in the case where it's not required to be free. The employer can self-operate the childcare centre and take on all the responsibilities and liabilities and all that needs to be contractually provided, and they need to have their documentation in place to apply for the registration of the childcare day centre. It can also be a multi-employer scheme if there's different employers who want to come together in a sort of a joint venture to set up the daycare centre, or it can be contracted out to a service provider who is in the business of providing childcare facilities and services, and who would have the knowledge, the know-how, the management skills, the staff, the training, and that's another structure for businesses to consider, very similar to the contracting out of the operation of hotels, for example, by companies that own the infrastructure of hotels.
The employer's obligation to hold an oral hearing before deciding whether to terminate a worker's employment in cases of misconduct or poor performance may be welcomed by workers who believe that they are better able to answer charges orally, rather than merely giving their written explanations. Yet, this obligation has several connotations, like the deployment of resources for the oral hearing, as well as the time ineffectiveness of oral hearings as compared to an opportunity to answer charges by way of written explanations only.